Hello, welcome to Learning Thursdays. I am Patty Corbett Ward, and I am a trainer at the OASAS Learning and Development Unit in Albany. I am pleased to be co-facilitating this presentation with one of my co-workers, Paul Noonan, who is the OASAS Coordinator of Veteran Services. I want to thank Paul and our presenters today for the effort, the time, the energy, and the flexibility they showed in order to make this presentation come to fruition. Gentlemen, thank you very much. Paul will be back in a few minutes to offer a history of the training, and he will introduce the training and our presenters. In the interim, I would like to provide a cursory overview of the Learning Thursdays educational series. A goal of Learning Thursdays is to support and help advance the educational and professional competency development of the treatment, prevention, and recovery workforce. We look to do this by offering monthly presentations that are current and relevant. This presentation, entitled Veterans Benefits, is one such training. As more military personnel come through your program's doors, more information is needed in order to provide effective, individualized, person-centered care and treatment. Your speakers for today will be Benjamin Pomerantz and Paul Stote, and as I said earlier, Paul Noonan will do more of an introduction. Very simply, as always, if you have any questions, feel free to send them to the mailbox at learningthurs@oasas.ny.gov. And that being said, I'm going to ask Paul Noonan to take over here. Thank you for joining us, and Paul, thank you for being here today.
Hello, everybody. My name is Paul Noonan. I'm the Veteran Services Coordinator for the Office of Alcoholism and Substance Abuse Services. And once again, welcome to Learning Thursdays. Every year we try to offer a couple of Learning Thursdays webcasts that have to do with the veterans population and their need to access evidence-based services through our system. In the past, we've usually limited those webcasts to the month of November, it being the same month as Veterans Day. But we're finding out that the need for information and the amount of information that needs to be made available is much larger, and we can't wait for 1 month each year for this to take place. So we're pleased to be able to offer this webcast on the rather complicated and confusing topic of veterans benefits. With me today are two gentlemen from the New York State Division of Veterans Affairs, also known as DVA. Well, DVA, to many of you, may not be a very well-known agency, but they have an enormous job advocating and coordinating and representing veterans in the area of the benefits that they're entitled to. OASAS is pleased to have had a very positive and productive relationship with DVA for the last 7 or 8 years, and they've helped us out in previous trainings, and I'm pleased to be able to renew that partnership with DVA, who actually came to us with the idea for doing this webcast on veterans benefits. And we think it's a great idea because it's a very different world. There are numerous, as many of us suspect, numerous benefits available on both the federal and state level for veterans. I'd like to introduce our two speakers. They are definitely subject matter experts in this area, and we're very happy to have them with us today. With me is Benjamin Pomerantz, who is the Deputy Director for Program Development at the State Division of Veterans Affairs. Mr. Pomerantz is also a Deputy Counsel with that agency. And also Mr. Paul Stote, who is a Veterans Benefits Advisor and also very knowledgeable in this area. Mr. Stote works out of the DVA's Saratoga Springs, New York office. Without further ado, let's jump right in. I'd like to introduce our two speakers. Thank you.
Good afternoon, everyone, and thank you for joining us today for this Learning Thursdays program. We're honored to be here in this partnership with OASAS And we're very glad to have this chance to spend the next couple of hours with you talking about a variety of benefits and programs and services for which veterans may be eligible. For anyone who is a veteran who is watching this webinar today, thank you very much for your service. And for anyone who's watching this who has ever worked with a veteran in the course of your career with OASAS, thank you for the service that you provide. It's a very important service, and we're very glad and grateful that you are there. The work that we provide as an agency, as we're going to talk about today, focuses on a different side of the Veterans Services realm. As Paul mentioned, it focuses on the avenues that veterans can explore when looking for benefits and programs on both the state level and the federal level, and we'll be touching upon both today. So we'll start with a brief overview of who we are as an agency and what we do, and then go into the topics of who exactly is a veteran, who are the people who actually qualify for these benefits and programs. And then we'll talk about the federal Department of Veterans Affairs, which is different from what we do, and talk about a number of the benefits available through the federal government. And we'll talk about the process through which veterans and their families can file claims with the U.S. Department of Veterans Affairs, the VA, to obtain those benefits. We'll talk about the VA's healthcare system and the services they offer. We'll talk about education benefits that are available. We'll talk about end-of-life benefits. And then we'll focus on some benefits that are available specifically for veterans in New York State. So at the outset, the State Division of Veterans Affairs. We are New York State's agency that is assigned by law, by Article 17 of the Executive Law, to be advocates for veterans and for their families who live in New York State. We are completely separate from the U.S. Department of Veterans Affairs. Even though our names sound similar, we are not employed by the VA. We are accredited with the VA. And what that means is individuals like Paul are officially accredited by the U.S. Department of Veterans Affairs to represent veterans and their families in claims and appeals for benefits that the federal government offers. Our job is to provide information and assistance to veterans in matters regarding veterans' benefits. We work very closely with our county partners who help veterans and their county veterans service agencies and other organizations like OASAS who provide different services for veterans and their families.
Big question that always comes out is, who is a veteran? And by definition, a veteran means a person who served on active duty military, naval, air, or who was discharged or released under conditions other than dishonorable. That's active duty Title X service in most cases. What it does not include is a National Guard person or a person in the reserves. But there is a caveat to that. There is what is called active Guard reserves, or Title 32, Section 502F. And active Guard reserve members receive the same treatment as an active duty member. Additionally, there's another caveat. If while doing your inactive duty for training or your weekend drill, you were injured, then you will be qualified and you get service connection for that injury, then you would be classified as a veteran. Okay, so the drill time when people in the Guard go to active duty for their basic training, active duty for their advanced course, those times are called active duty for training, and they do not count for veterans' benefits.
Another common question that people have when they begin to look at veterans programs and services and benefits is, where do we find these people? Where do veterans live? Well, the short answer, especially in New York State, is all over. There's approximately 900,000 veterans, according to federal estimates, living in New York State right now. And to get a sense of the demographics of that population, it's worth noting that more than 270,000 of those veterans are from the Vietnam era alone. So in New York State, we have largely an older veterans population, a lot of veterans from World War II era, Korean War era, and the Vietnam era. But we have veterans, of course, all the way up through the present and current conflicts that are going on in the Middle East. And it's important to note, and we'll go into this in more detail later, that as far as qualifying someone in terms of wartime service, right now we are currently in what is called by Congress a wartime period, the Gulf War period. New York State is the 5th largest veterans population of any state in the country, and among the counties in New York State, Suffolk County on Long Island has the largest veterans population of any county in the state. The U.S. Department of Veterans Affairs, as I mentioned earlier, is separate from our state agency. However, because so many benefits go through the U.S. Department of Veterans Affairs, the VA, it's important to get a good sense of who they are and what they do. It's a federal agency comprised of 3 branches: the Veterans Benefits Administration, or VBA, the Veterans Health Administration, or VHA, and the National Cemetery Administration, or NCA. And so a good way to think about this is if you're looking at the different VA medical centers, the hospitals, the community-based outpatient clinics, and so on, those fall under the Veterans Health Administration. If you're talking about programs where a veteran is going to get some kind of a compensable benefit for disability compensation, for pension, for education payments, that's the Veterans Benefits Administration. And if you're looking at burial benefits, including, of course, burial in a national cemetery, that's the National Cemetery Administration. It's also important to note that these 3 branches, these 3 silos or cylinders in this federal agency, often have difficulty communicating with each other. It's important to know that because you can't automatically assume that a veteran who is receiving care, for instance, through a VHA facility is automatically having information transmitted over to the VBA side of the house. So that's a role that our agency can play to help veterans get the information they need to send to the proper points of contact in the VA to apply for benefits and services.
Okay, the federal benefits, federal VA benefits. We're going to touch on these in a lot more detail as we go through the brief, but you have compensation, then we'll have dependents and survivors benefits, then what's called a non-service connected pension, that both for the veteran or for a surviving spouse. I'm going to touch a little bit on education benefits. We could have an entire 2-hour discussion on that, but we'll just kind of give a general overview on that. For the purpose of this brief, we're not going to go into any detail on the home loan guaranteed program, or we're not going to go into VA life insurance during this program. But we are going to get into some depth on health care and burial benefits.
There are also certain benefits that are unique to New York State, and we'll go into those as well. In particular, we're going to talk about 3 different tuition awards or scholarships that are available for certain eligible veterans and for individuals in veterans' families. We'll talk about the governor's hiring program for veterans with disabilities under Section 55C of the state civil service law. And then we'll also talk about the Homes for Veterans program, which is a program that creates fixed mortgages for veterans who want to buy a home, and it creates a mortgage rate, an interest rate, which is lower than the typical rate you're going to see out there in the common market. We'll talk about the real property tax exemptions that exist for veterans who own land and homes in New York State. And we'll talk about the state veterans nursing homes, which are facilities where a veteran can receive skilled nursing care for a cost significantly less than what you would typically pay in a private facility. Also, there are certain benefits that are available unique to the individual counties where the veterans live. These benefits differ, of course, by the county where the veteran resides, but they may include things like daily van transportation from the veteran's residence to a U.S. Department of Veterans Affairs medical center. It may include certain discounts in businesses within that county. And it may include a veteran ID card. And this is very important because when a veteran separates from military service, he or she is going to hand in his or her military ID card to the military. Now the only thing that that veteran has on his or her person when they first get out is going to be a piece of paper, their Department of Defense Form 214, to verify that they're a veteran. If you have a county that has an ID card, it's good to encourage a veteran to obtain that ID card because it's very simple proof to show to anybody who asks that this individual is in fact a veteran of the armed forces. And I know, for example, Saratoga County, where Paul's office is, has a veteran ID card. There's a veteran ID card that was recently established in the boroughs of New York City, and other counties have those as well.
What are the required documents? As Ben mentioned earlier, the DD-214 or your discharge. That's not that wall hanger we're talking about that says honorable discharge that everyone has on display. It's the actual form that tells when you went into service, when you got out, and most importantly, a lot of times for different benefits, the character of your service. The DD-214 came out around 1950 for the Army and then phased in at different times throughout the different services. But anyone looking for a pension or service prior to 1950, you may have some of the legacy forms like the WD-AGO 5355 or the NAVPERS 553 as proof of your military service. This is the only document that is recognized by all the agencies for your military service. There was a fire at the National Personnel Records Center where all of the records are kept back in 1973. It was actually on July 12th, 1973, and during that fire, what's called the Blaze of 73, approximately 16 to 18 million veterans' records burned or were destroyed by water damage also. A lot of the ones that were affected were from the Army from 1912 all the way up to 1959, and in the Air Force from 1947 through 1963. So if you're trying to find any records during that time, there is a program down there to reconstruct the records, and if they're able to reconstruct the records or you provide documentation, they can provide you with a certificate of military service. Some other documents you want to get is also your official military personnel file, your service treatment records, or any VA or outpatient records, and we can use those to help develop and substantiate your claim. What is compensation? A tax-free payment, and that's a key thing. Tax-free payment, exciting slides here. Tax-free payment made to a veteran due to service-connected disability or disease incurred or aggravated by their military service. There is also what's called dependency indemnity compensation, or DIC, and that again is a tax-free payment made to a widow or child of the veteran because they died of a service-connected condition, okay? Veterans benefits are for veterans, but in this case, if the veteran died of a service-connected disability, we're going to go ahead and compensate the spouse for that death. The different parts of the claim, what I like to call the three-legged stool, all right? You have to have a disability or disease aggravated in qualifying military service, a diagnosed current condition for that disease or injury, and a nexus or link between the two. As we get further separated from our active duty military service as time goes on, that nexus or that link becomes harder and harder to prove due to extenuating circumstances of your employment or other outside injuries. In VA, there is also what are called VA presumptive conditions, where Congress has stated that they are going to go ahead and presume the nexus or the link between a condition you have and your military service. The claims process is a pro-claimant situation where if there is a tie or equal evidence for the veteran and against the veteran, the tie will go to the claimant or the veteran in this case.
As Paul mentioned, the VA system is established by Congress to favor the veteran whenever possible. It's specifically designated by Congress and by subsequent case law to be a pro-claimant, non-adversarial system. And as part of that, as established in a court case heard by the Federal Circuit called Cushman versus Shinseki, veterans have a constitutionally protected due process property interest in VA benefits for which they are lawfully eligible. Meaning that if you have a veteran who is eligible for disability compensation, pension, federal education benefits, a surviving spouse eligible for DIC, burial benefits for the family, any of those benefits that fall within the federal government's veterans benefits purview, anyone who is eligible for them, the federal government has no discretion but to award those benefits to the veteran or to the veteran's family. And so they have certain legal rights and certain protections that are established because they have a constitutional guarantee to receive a particular level of process. They have to receive fair notice, an opportunity to be heard before the U.S. Department of Veterans Affairs with regard to these benefits. They can't just be denied arbitrarily. In addition to that, federal law also states that the VA has a statutory duty to assist claimants in applying for VA benefits. Again, this is a pro-claimant system. So the VA has a lawful duty to do a variety of things, most importantly, telling the claimant if there's missing evidence in his or her claim packet. To go back to this person and say, okay, we have parts A, B, and C, but you're missing Part D, and here's exactly what we need. They are not allowed to be vague about this. They must specify the exact materials that need to be added to the claim. The VA is required to make reasonable efforts to obtain any VA records or other federal agency records pertaining to the veteran. And they also have an obligation to grant what are called inferred claims. So if a veteran files for a particular benefit, and that veteran provides evidence to the VA, and in that evidence the VA notices that this veteran is eligible for some other type of benefit. Say you're filing for disability compensation, and the veteran files for 3 specific conditions. And in reviewing the evidence, the VA notices that there is a 4th condition for which this veteran is pretty clearly eligible. The VA can't just say, oh, we're going to deny this claim because the veteran didn't list the 4th condition. The VA has an obligation under their statutory duty to assist to grant the claim if the evidence is there in that claims packet, even if the veteran is not requesting that particular benefit. Line of duty and willful misconduct. This will be very important to think about when you're working with individuals in the alcoholism and substance abuse counseling context. General rule is that within the VA system, you cannot get disability compensation for a disability that is incurred by your own willful misconduct. But there's a couple of interesting exceptions to that. The first one focuses on claims filed prior to October 31st, 1990. And in that situation, you could have someone who receives service-connected disability compensation for alcoholism or for substance abuse. So one area you'll look at commonly for that will be individuals from the Vietnam era who may have filed for these claims. They do have that eligibility if the claim were filed before October 31st, 1990. After that date, you start getting these laws regarding willful misconduct, and as part of willful misconduct, the VA includes alcoholism and substance abuse. But there's a caveat to that. And the caveat to that is the fact that you can have a claim for alcoholism or substance abuse that is secondary to a different disability condition. Paul will talk in greater detail later about secondary conditions, but in a nutshell, think of it this way. Let's say you have a veteran who files a claim for post-traumatic stress disorder, PTSD. And that veteran gets that claim granted by the VA. They've managed to prove to the VA satisfaction that their PTSD was as likely as not linked to their military service. Now that veteran, if he or she is abusing alcohol or abusing illegal substances, could file a claim with the VA and say that their alcoholism or their substance abuse is a secondary condition to their PTSD. Because of their PTSD and because of the effect that PTSD has had upon them, they have turned to alcohol or substance abuse to self-medicate or a similar justification of that nature. And so that is still on the table as a claim that a veteran could win for disability compensation. So not for a primary condition, but for a condition secondary to a different service-connected disability.
Okay, I always have to grab the show me the money slide. So when we look at compensation rates, the first thing we're always looking at for a veteran is to try to get them service-connected disability or 0% disabling. If you file a claim with the Department of Veterans Affairs and you actually get a 0% rating, believe it or not, you won your claim. You are now service-connected for that condition, and you get free VA health care for that condition for the rest of your life. Veterans always want to be shown the money a little bit, so the compensation rates for the Department of Veterans Affairs go anywhere from 10% all the way up to 100% in increments of about $133.17 for 10%, all the way up to $2,906.83 for a veteran alone at 100%. Okay? The increments are in increments of 10, and this is what is called your combined service-connected rating. Okay? There's a thing what we like to jokingly call VA math, and that 10 plus 10 plus 10 plus 10 plus 10 is not 50, it's actually 40. And I like to explain this a simple way is, let's say I'm service-connected 50% for my right arm, 50% for my head and 50% for my left arm. Well, 50 plus 50 plus 50, you're going to say is 150, but I would actually be 90% service-connected disability. And it's done what they call the whole person concept. So we'd take the first condition, my right arm, which is 50% disabling, and they would say I'm 50% disabled, but the rest of me is 50% able. Then we would take the next condition, my head, and do 50% of the 50% of me that is able. That would equal 25%. You would add that to the first condition, my right arm. I'm now 75% disabled, 25% able. We would take the last condition, which is my left arm, and take 50% of the 25% of me that's able. That would be 12.5. Easy math, I add it to 75. I'm now 87.5% disabled. Since I'm 85 or above and VA compensation is only done in 10% increments, I would be 90% combined service-connected rating. Now there are other things that go into effect, like there is bilateral factor, which would go into that, but that's kind of a simple explanation of that. They're also going to pay you additional money if you have children under 18 years of age or 18 years to 23 years of age while attending school. And the big thing with VA compensation is all tax-free. We'll never get a W-2 or 1099 or anything at the end of the year for that. There's also a thing on top of that called special monthly compensations that are in addition to VA compensation. They're add-ons to VA compensation. It's a benefit established through a statute that is paid in addition to the basic rates of compensation. And they're payable under a special scheduler of ratings. It is paid to compensate the veteran for loss or disabilities involving an anatomical loss of, say, a foot or an arm or something like that, or a loss of a sense. One of the most common one we see is special monthly compensation K, or loss of a creative organ normally due to a mental health condition such as PTSD or something like that. Okay? As been alluded to earlier, I talk about secondary condition, a condition that's available for most any disability that is a result of another service-connected disability. The disability is proximately due to the result of a service-connected disease or injury shall be service-connected, and the reference is 38 CFR 3.310. One I like to use an example for this is diabetes mellitus type 2, or adult onset diabetes, which is a presumptive condition for Agent Orange. All right? Secondary conditions we see a lot is peripheral neuropathy of the upper extremities, peripheral neuropathy of the lower extremities, diabetic retinopathy, nephropathy or kidney failure, and also hypertension. These are all secondary conditions that as this disease develops and progresses over time, the veteran could be service-connected for. Unless you file for these secondary conditions, the VA is not going to automatically grant these conditions.
So you think about this concept, again, looking back to our hypothetical earlier regarding PTSD and a secondary condition for alcoholism or substance abuse. So what you would actually be arguing to the U.S. Department of Veterans Affairs is you have your primary disability, PTSD, which is service-connected, and your secondary disability of alcoholism or substance abuse is proximately due to the symptoms and effects of PTSD. And so therefore both the PTSD, the primary condition, and the alcoholism, the secondary condition, should both be service-connected.
And you would receive a separate compensation rate for that alcoholism then. There's what are called VA presumptive conditions, and I kind of touched on these a little earlier, but the VA presumes certain disabilities were caused by your military service, okay? The ones we see are tropical prisoner of war related diseases, diseases due to exposure to herbicide agents such as Agent Orange is probably the most common one. And these are all listed under the 38 CFR 3.309. And they're going to be outlined in this section even though there is no evidence that such a disease was established during your period of service. The National Academy of Sciences has done research and they have found that you are 40 or more 30% more likely to have these conditions. Let's look at Agent Orange. If you served boots on ground service in the Republic of Vietnam and you now have diabetes mellitus type 2. So Congress has stated that we're going to go ahead and presume that nexus or that link between those two conditions. So in a presumptive claim, you just have to show qualifying military service for that exposure in this case and a current condition. That's the only two parts of the claim you need. Some of the most common presumptive conditions are Agent Orange, and the key phrase we always use is boots on ground service in the Republic of Vietnam. They also qualify brown water Navy, so your ship went up the rivers, up in the rivers of the Vietnam Peninsula there. There's also 15 major conditions that are linked to presumptive condition for Agent Orange. There is one that is for the offshore, for ships that served in the, I guess you would call it the combat zone, but offshore waters or blue water Navy, which is non-Hodgkin's lymphoma. So you could be 200 nautical miles off the coast of Vietnam, but if you come down with non-Hodgkin's lymphoma, they have said that you got it due to exposure to Agent Orange. There's a bunch of chronic diseases that once you get within 1 year of separation from active duty military service or qualifying service, you can file for a chronic disease such as I filed for diabetes mellitus type or diabetes type 1 diabetes. If you develop that within 1 year, or arthritis, it's presumed, since that is a long duration disease and it's and how it affects you, it's presumed that you had that disease during your active duty military service. Mustard gas, ionizing radiation, Persian Gulf War, or multi-system undiagnosed illness. You'll see stuff in that like fibromyalgia, chronic fatigue, irritable bowel syndrome, or some of those. ALS or Lou Gehrig's disease. If you ever served in the active duty military for 90 days and get Lou Gehrig's disease, it is presumed to be caused by your military service. I find that one ironic, as Lou Gehrig's disease is a genetic disease. But Congress has stated that. There's a bunch of conditions. If you were a POW, such as arthritis, PTSD, ischemic heart disease, or stroke, and also multiple sclerosis if diagnosed within 7 years of qualifying active duty service. There's a couple new presumptive conditions that are out there that a lot of people may not know about. One, if you were in the National Guard or Reserves and you worked on C-123 aircraft, which were the spray aircraft for Agent Orange in Vietnam, they discovered that the herbicide may be present in that airframe for a long period of time, and you may have been exposed to it if you were someone who worked in and around the aircraft like a mechanic. There's also the contaminated water at Camp Lejeune with the PCE and TCE contamination down there between 1957 and 1987. There's 15 presumptive conditions for that, most of them cancers like renal cancer, stuff like that. And that has also opened you up to health care because of those exposure if you had children or a spouse that lived with you on Camp Lejeune.
Now we turn to the compensation benefit, which focuses on the survivors of a veteran. As Paul mentioned earlier, dependency and indemnity compensation, commonly abbreviated as DIC, is a tax-free monthly payment to a widow, child, or income-dependent parent of a veteran because of the veteran's service-connected death. The veteran passed away because of at least one of his or her service-connected disabilities. To qualify, a spouse must be married to the veteran for at least 1 year prior to the veteran's death, or the spouse must have had a child with the veteran. For a child to qualify for DIC, the child must either be under the age of 18 or between the ages of 18 and 23 and attending school. How does a death qualify for DIC benefits? There's a couple of different ways. The most common way is the individual veteran died from an injury or ailment proven to be related to his or her military service, service-connected. Or you could also qualify as a survivor for DIC if the veteran died while on active duty for training purposes, or inactive duty training. Or, and this is the one that can become somewhat complex, if the veteran died from a non-service-connected disease, but was receiving or was entitled to receive VA disability compensation with a rating from the VA showing that this particular disease, this particular condition, was totally disabling for a period of at least 10 years before the veteran's death, or for a period of at least 1 year before the veteran's death if the veteran was a former prisoner of war who died after September 30th, 1999, or since the veteran's discharge or separation from active duty military service, and for at least 5 years immediately preceding the veteran's death. That's a mouthful. The main advice that I can give based on that whole long paragraph, and you'll hear this advice repeated throughout the course of the presentation today, is you don't have to memorize these things word for word. But if something seems to ring a bell when you are talking to someone who is the surviving spouse or child or dependent parent of a veteran, give us a call. We'll have our contact information at the end of this presentation. We're here to interpret the alphabet soup like that last paragraph. That's the job of our agency, and we're happy to do it. So you don't have to take it upon yourself to try and weed through every possible permutation here. Let us do that process for you.
One thing I want to caveat on the qualifying death, it's very important. The one document you're looking for here is the death certificate.
Yes.
They need to make sure that either the service-connected condition is listed as the primary cause of death or one of the contributing causes of death. Too often, doctors like to write multi-system organ failure at the end of life, and that's not something we can work with there.
It has to be specific enough for the VA to link it to that service-connected disability. It's important to note also, if you're going to get a death certificate for the purposes of applying for DIC or any other federal veterans benefit, according to New York state law, the person who obtains a death certificate for that purpose gets that death certificate free of charge.
Okay, we're going to change gears a little bit and go into vocational rehabilitation. And this is a program that for your organization may be something you really wanted to look into about getting people retrained and back into the workforce. But it's basically designed to help a veteran with a VA service-connected disability get substantially gainful employment or get back into the workforce as a productive member of society. And also help a seriously disabled veteran achieve independence in their living environment out there, okay? The bottom line is, in most cases, 99% of the cases, I would say, you must be service-connected at least 20% or greater. There's a caveat that if you have a 10% rated disability that incurs a serious employment handicap, in my 7 years, I have not seen that to date, but it is out there in the law. When you go for voc rehabilitation, they really set you up for everything you need to go ahead and be successful. If they're going to get you in a retraining program, they're going to pay all the tuition and fees. They're going to pay for any books you need, any type of supplies you need, and any type of equipment. If you're going back to school, they're going to buy you a new computer. They're going to give you all the software you need. They're going to get you a printer and whatever you need to go ahead and get into an Institute of Higher Learning or a non-degree program. If you're going, they decided, you and your counselor decide you're going to be a motorcycle mechanic. They're going to buy you a new set of tools, test sets, and equipment you need, so when you step out of there, you're ready to go get a job and get back in the workforce. They're also going to pay a subsistence allowance, there we go, English today, that will help you pay the bills while you're going to school and getting retrained. And a change to the laws that allows you, if you are qualified for what's called Chapter 33 or the post-9/11 GI Bill, and given voc rehabilitation, you can use the BAH rate as your subsistence allowance, which is going to be a lot higher than the one provided at voc rehab. There's also what's called a non-service connected pension, normally used as a non-service connected pension with aid and attendance. There's two parts of this. There's the non-service connected pension for the veteran, and then there is the death pension for the spouse. As the name implies, with the death pension, the veteran must be dead. Spouses don't get any ideas out there, okay? But it's a monthly payment based on the need of a wartime veteran. So while compensation is income independent, as we say, VA pensions are income dependent, all right? And it's for a non-service connected disability or death. If you are over the age of 65 years of old, they figure you're already disabled. I'm getting close to that, so I'm getting a little scared here. Or if you're in receipt of SSDI or SSI or in a nursing home, you do not require a VA medical examination. They're going to look at your income minus your unreimbursed medical expenses. One nice thing about this is the way the law is currently written is that unreimbursed medical expenses can count the entire amount of an assisted living facility's costs. So while they may actually be broken down into room and board and care, they count the entire cost of that assisted living facility as a medical expense. You have to, required for the aid and attendance portion of that, or the special monthly compensation for aid and attendance, you must need assistance with 2 of the 5 activities of daily living, the feeding, bathing, dressing, personal hygiene, and Ben's going to cover those in a little more detail later on in the presentation. And this is one of the most underutilized benefits out there. So hopefully we'll get this out to everyone in your agency, and it may help someone who your agency is helping, or they may know a friend or a parent or a World War II veteran who may be able to benefit from this benefit. Eligibility. For length of service, at least 90 days of active duty qualifying military service prior to 1980, September 7th. After that, with a lot of the newer benefits, we're looking at 24 months of active duty service or the full time of your call-up or enlistment. So if you were in the National Guard, activated for Title X service for 1 year, you completed your entire period of service, you would be qualified for this benefit. And the character of service for this benefit is other than dishonorable. Some other benefits do require a straight-up honorable discharge, most notably education benefits. Pension eligibility. Basically, you're looking for wartime service. Only 1 day of that 90 days needs to be during wartime service. And I'd like to call your attention to the Gulf War period. It is from August 2nd, 1990, to be announced. So this is still going on for anyone in service. They have wartime service eligibility. Turn over to Ben for the medical requirements.
One last word on the wartime eligibility, just to drive home a common point which is overlooked. Wartime service does not mean the individual has to be serving in a combat zone.
Yeah.
Often veterans will come to us and they'll say, oh, I don't qualify for that because I don't have wartime service. And you talk to the veteran, it turns out, in fact, they served for a couple of years during a wartime period, but they never actually served within the perimeter of a combat zone. That does not matter in any way, shape, or form for VA non-service connected pension eligibility. The main thing is the individual served for at least 1 day on active duty service during one of the wartime periods set by Congress.
During a time of war.
During a time of war. As Paul mentioned earlier, the VA makes an interesting assumption with regard to the medical requirements for a VA pension. They make the assumption that any individual who is age 65 or older is totally and permanently disabled, therefore no medical exam is required. That's a very peculiar assumption to make, but it saves a step in the application process, so that's a good thing. An individual below the age of 65 who can prove by medical examination that he or she is totally and permanently disabled according to the VA's evaluators on the medical side would qualify. An individual receiving skilled nursing care as a nursing home patient qualifies under the medical side. And individuals who are receiving SSDI or SSI would also qualify for the medical requirements for a VA pension. And then lastly, you have the income and net worth side. As Paul mentioned, disability compensation bears no relation at all to income. VA pensions are income-based. The income must fall below a threshold set by Congress, and it's changed on an annual basis. Also, on the assets side of the house, the personal holdings side of the house, generally you're looking at an individual who has below $80,000 worth of assets in his or her name. Now, it's not an exact standard. There's nothing in law that mentions $80,000 as an absolute threshold. What the VA uses is a matrix that is based upon typical life expectancy. So how that comes into play, let's say you have a veteran who is 95 years old, a veteran of the World War II era. That individual's asset threshold is going to be very different than, say, an individual who is in his or her 50s, because the VA's life expectancy matrix will create a different result. So the $80,000 threshold is a general standard. It's not absolute in any way. Unreimbursed medical expenses. This is kind of a spend-down process that a veteran can use or a surviving spouse can use when applying for a VA pension. If you have unreimbursed medical expenses, costs of medical care that your insurance did not reimburse, this may reduce the income that you have to declare as countable income to the VA. And it's very important, again, just to reinforce what Paul said earlier, assisted living expenses in their entirety count as a medical expense, and if you don't have insurance covering all or part of those costs, that money qualifies as an unreimbursed medical expense, and that can really help a person gain eligibility on the income and asset side for a VA pension. The VA wants to know more than just what you're making from a job. When they talk about income, they're talking about any interest that's coming in from your bank accounts, any dividends from stocks, any income coming in from bonds, mutual funds, annuities, any property other than your residence and a reasonable lot area. So they have a pretty wide definition of the term income. Unlike the Medicaid system, there is no look-back provision. That means, technically speaking, a veteran or a surviving spouse could transfer his or her assets into somebody else's name on day one, and on day two, file an application for a VA pension and not have to declare any of those assets, because at the time the application is filed for the pension claim, those assets are in somebody else's name. But the cautionary tale that I want to put forth is there is, of course, the look-back provision for Medicaid purposes. And so if you're moving assets, particularly if you're moving a large quantity of assets into somebody else's name, before you do that, make certain that you consult with a qualified professional who can talk to you about what the consequences of doing that for Medicaid eligibility might be. Because there are some situations out there where veterans and spouses have heard, oh, good, I can take the assets and move them today and apply for a pension tomorrow. That's fine on the VA side of the house, but it can have some negative consequences for Medicaid eligibility down the road. So be certain that if you're working with a veteran or a spouse, he or she has that information in hand so they can make an informed choice about what they want to do. The income and asset thresholds for pension benefits differ depending on how many dependents live in the veteran's household, and we'll get to that in a second regarding what the actual thresholds are.
One thing on this, as Ben said, moving the assets, the vehicle you're looking for with this is it has to be a irrevocable trust is the only thing the VA specifically will look for if it was put in an irrevocable trust. And again, there could be penalties and other things as you discussed there.
Special monthly compensation on the pension side, and Paul mentioned earlier how underutilized of a benefit this can be. A couple of years ago, the New York Times ran an article talking about aid and attendance. And in the course of its study, the Times discovered that there were literally millions of dollars on an annual basis left on the table by veterans who were older, who had disabilities, who needed assistance with at least 2 activities of daily living, and yet no one ever applied for this benefit, either themselves applying or to have an advocate to come in and help them apply for it. That was tax-free money that was lost. And so just to reinforce that, if you're working with anybody who seems to fall into these categories, please make certain that you tell them that they might be eligible for this and get them in touch with us so we can evaluate their case, and if they are eligible, file the claim on their behalf. So we're talking about special monthly compensation on the pension side. You have basically two different categories that you're looking at: aid and attendance and permanently housebound. On aid and attendance, you're looking at veterans or their surviving spouses with disabilities requiring regular assistance in at least 2 activities of daily living. What do these activities of daily living include? Well, some of the most common ones: inability to bathe oneself, or dress oneself, or feed oneself, incontinence, limited ability or inability to move around, to ambulate from place to place. Another common one is an individual who is in a nursing home because of a mental or physical incapacity automatically satisfies this requirement for activity of daily living needing assistance because you're in a skilled nursing facility under that high level of care. Also, a veteran or a surviving spouse who is legally blind, which is corrected vision of at least 5/200 in both eyes or a field of view of 5 degrees, that qualifies as an activity of daily living that the individual cannot meet independently. If an individual needs protection from the hazards of daily living due to a mental or physical disability, say for instance the individual suffers from dementia, that qualifies. And when it comes to special monthly compensation, don't forget we talked earlier that this can also be applied to disability compensation as well as DIC benefits and for the whole complement of pension benefits as well. I get the money slide for the pension payment rates. Somehow Paul gave me a money slide for once to talk about. To show me the money slide. A couple of important things to look at here. These are the thresholds that are set each year by Congress as being the maximum amount of money that a veteran or a surviving spouse can be receiving in income. And they list both annual income and monthly income thresholds to be able to qualify in the income piece for a pension benefit. Now, notably, you have a couple of different categories. The thresholds for veterans are not the same necessarily as the thresholds for a spouse or for a widow. And the thresholds for a veteran applying for a regular VA pension differ from the thresholds for a veteran or a surviving spouse applying for pension with the enhanced benefit of aid and attendance. Now, to be deducted, as we talked about earlier, the deduction for unreimbursed medical expenses. The medical expenses have to exceed a threshold of 5% of the maximum annual, or the minimum annual pension rate. So again, you have to look at what the amount that's set by Congress is each year. Then you look at your unreimbursed medical expenses, and you have to do the mathematical calculations, which Paul, of course, loves to do, and determine, does that cross that 5% threshold? If it does, the amount by which it crosses the 5% threshold becomes the amount that you can deduct from the individual's income to get the reportable income that you can send to the VA. And hopefully the goal is your unreimbursed medical expenses will get you below whatever the applicable threshold is to qualify the person for a VA pension.
I'm going to talk a little bit about filing a claim, and that's basically what I do, day in and day out after talking with veterans. The way I kind of explain it to veterans is think of me as your insurance agent, okay? So if a tree falls on your house and you sit there and look at the tree on the house and the hole in your house, nothing is going to get done unless you call your insurance agent. And if you call your insurance agent and he doesn't file a claim with the insurance company, no one's going to give you money to fix your house. So if you're the broken house, you need to come see me so I can file the claim and get you fixed, okay, or get you compensated for it. It's basically a request for benefits from the Department of Veterans Affairs. The two major ones we do is compensation, as we've discussed, and the non-service connected pension. Now, there are a bunch of different claims, like I could do a health care claim, we could do a VA home loan, a CHAMP VA claim. There's a myriad of claims, but those are the two major categories that they all pretty much come under. There are several types of claims you can file just under compensation. The first claim that you would ever file with the Department of Veterans Affairs is called the original claim. And the key thing with an original claim is that it must be signed by the veteran or the claimant being the surviving spouse. Okay, the original claim must be signed from them. We would go ahead as a service organization and take what's called a claimant representation, or basically a limited power of attorney. We can file all of the subsequent claims after the original claim on behalf of the veteran. But the original claim must be signed by that veteran or surviving spouse. Once you filed an original claim, the next claim you could file, any other claim after you file, is probably going to be a new claim or a new claim for benefits from the Department of Veterans Affairs. That could be a brand new condition that you forgot to claim, or that could be a secondary condition due to a service-connected other condition. Then there's what's called a reopened claim. That's where you've filed a claim, it has been denied by the Department of Veterans Affairs, and your appeal period has run out without you filing an appeal. Then you would have to reopen that claim. Is a little harder than filing a new claim. You must reopen with new and material evidence contrary to the reason the claim was denied. So if there's nothing in your service treatment records, and that's why they denied your claim, you would have to somehow find something in your service treatment records to reopen that claim. Then there's going to be a claim for increase, a claim, and that'll go under a new claim, but that's a claim to increase your compensatable rate because your condition has gotten worse. So that service-connected condition, through a natural progression of the disease, has gotten worse. If you do not file a claim for increase, you will remain at that rate. Okay? One thing is, when you file for a claim for increase, the VA is going to rate the current state of your disability. It could go up, it could go down. And there's some rules that govern those called the 10-20-year rule. The first 10 years, you could actually lose service connection for that disability. Between 10 and 20 years, you can never lose service connection for it, but the rate could be reduced to 0. And then after 20 years of having that service-connected disability, it is called a protected disability or a static disability. It will not be changed. There's also claims for special monthly compensation, which we touched on. Another claim is called total disability individual unemployability. So I have one service-connected condition at 60% or more disabling that keeps me from having substantially gainful employment. Or I have a combined service-connected rating at 70% or more and one condition 40% or more disabling that keeps me from having substantially gainful employment. There are other nuances to that, like all from the same injury or incident, or same, like all orthopedic injuries can be combined to come up with those ratings. If you have a service-connected disability and you have to undergo a surgery that has a time of convalescence, you could get what's called TDCC, total disability convalescence. So if I was 20% service-connected for my shoulder, I went and had surgery, I have a 3-month recovery, my 20% condition would be raised to 100% for the 3 months while I'm having that convalescence. So you can see $247 up to $2,900 is quite a difference, so it behooves you to file that claim. And then there's 1151 or medical malpractice claims, sometimes called tort claims, where you have had negligence in VA care and you are filing for a service-connected condition due to the negligence of that VA care. I already covered basically secondary conditions that you can file for, and then there's claims for survivor's benefits, accrued benefits, substitute claimant, where they'll take over the claim of a deceased veteran, or dependency indemnity compensation. Filing a claim for non-service connected pension with aid and attendance or death pension with aid and attendance, what we like to use is what's called the fully developed claim program. This allows the veteran to provide all of the medical documentation or the development of their claim to help the VA adjudicate their claim quicker. Normally when a claim goes in, it has to go through a full development process, and then they will go ahead and move it forward to a veterans rating specialist who will go ahead and rate the claim. In this case, we are gathering all the medical documentation, any medical nexus statements, any military, non-federal military records, and we are providing those to the Department of Veterans Affairs to look at our claim, send it to a rater, and go ahead and get it rated quickly. The goal of the fully developed claim is about 90 days, and we can do these for pensions, dependency indemnity compensation, and for compensation claims. They're a great program, and New York State Division of Veterans Affairs has been kind of leading the charge with those in New York State to get those fully developed claims done. On March 24, 2015, the VA went a gigantic change basically in the claims process. Prior to that, you could file a claim on simply a piece of paper. I write "my right shoulder hurts," drop it off at the VA with my name, and that is a claim. That caused a lot of development on the VA's half and probably added to our claims backlog that we have. So on that date, the VA went to standardized claim forms, which one is an intent to file, which basically says, hey, I'm thinking about filing a claim. I got to gather all this information for you, but I'm going to go ahead and send this in on a standardized form, and you can mark my date of claim that I can be paid back to. All right? And then we went with the standardized forms for filing the claim, the 526EZ and the other ones. Since Ben's the lawyer, he gets to talk about the appellate process.
About the appellate process. This is always a fun one. This will be a briefing in a nutshell about the appellate process. It can have many different twists and turns and loop-de-loops as it goes forward. But essentially, what happens when you file a claim? Your initial claim with the VA will go to a VA regional office. New York State has two. One's in Manhattan and one is in Buffalo. The VA regional office makes the initial decision on that veteran's claim or on that spouse's claim or child's claim, whoever is filing the application for benefits. They will then send their decision, and if they're awarding benefits, the percentage rated, if it's a disability compensation case, in what's called an award letter back to the veteran, or a benefit notification letter. Let's say that the claimant disagrees with what the VA decided. Again, we talked about due process earlier. Part of that due process means the veteran or the spouse has the right to file an appeal. The appeal begins with the filing of a form called a notice of disagreement. Technically, the notice of disagreement itself does not mean it's an appeal, but it starts the appellate process. And there's two different things that you could do. One is you could try and go directly to what's called the Board of Veterans' Appeals and try and get a hearing there in front of administrative law judges. Or you can take the initial step of going to a decision review officer, a DRO as they're commonly called, at the VA regional office level. If you want to go with the DRO route, it's often a good idea because you get two bites at the apple. You get to go before the DRO, have the DRO consider your appeal, and then if the DRO gets back to you and you don't like the DRO's decision, you then can go forward and go to the Board of Veterans' Appeals, the BVA, to try and get the decision reversed. So if the DRO grants your appeal, then you've kind of reached the end of the road. You're satisfied. You get a rating decision from the DRO. If you aren't satisfied, you'll receive what's called a statement of the case, which is where the VA says, here are all the reasons why we disagree with your position of why you think your appeal should prevail. You then have 60 days to respond with your arguments of why the VA is incorrect. If the VA still wants to disagree with you, they'll send back what's called a supplemental statement of the case. And again, you have a time limit of 60 days to respond to that. When you get to the point of filing an appeal to the Board of Veterans' Appeals, you file it on what's called a VA Form 9, and you file that to this body which exists within the VA, but it's not the same as the DRO level because the BVA is reviewing the case with a fresh set of eyes. The fancy legal Latin term is de novo review. They're looking at it as if they're seeing it for the first time. And you can have them evaluate this without a hearing, or you can request a hearing. Paul loves to do the hearings because he likes to argue. And you can actually go before these administrative law judges and argue your case in person. Let's say you're still not satisfied with the BVA's decision. You can file a motion for reconsideration with the BVA based on one of two grounds. One, that you've found clear and unmistakable error in what the VA has decided thus far, or based on the fact that new and material evidence has come to light that you want to present before this tribunal to say, hey, this is something I didn't file originally, But because you're a pro-claimant system, here's some new evidence that you should consider to view the veteran's case or the spouse's case in the best possible light. If you still aren't satisfied with the results there, then your next level of appeal is to the United States Court of Appeals for Veterans Claims, which is a body that's based in Washington, D.C., and it has sole jurisdiction for evaluating claims for veterans benefits. And again, they look at this with a fresh set of eyes, and they have no relationship to the VA whatsoever. It's a truly independent tribunal. And if you're dissatisfied there, you have a right to appeal another rung higher to the United States Court of Appeals for the Federal Circuit. And then in the rare instance where there's still an issue that you want to pursue, the highest level of appeal is actually the United States Supreme Court. And there are U.S. Supreme Court decisions on the books that deal with a denial of veterans benefits or an inadequate process in terms of granting or denying veterans benefits.
Veterans health care. The biggest thing I want to talk to you about with veterans health care is that veterans health care is not a health insurance. Veterans health care is an integrated health care system, okay, for eligible veterans. It goes from primary care all the way through specialty care to include mental health care. Guess you can't bang the table here. Provides mental health counseling at VA medical centers and vet centers. Also at community-based outreach clinics. We're satellites of the VA hospitals. Low-cost dental insurance is something that came on board about 2 years ago for veterans, not for the family members. The co-pays are very free, go from anywhere from free if you're service-connected for that condition or have a combined service-connected rating of 50% or more, to $15 for primary care or $50 for specialty care. And the pharmacy is again free if you're service-connected for the condition or 50% or more service-connected disability or $9 to $12. They also have audiology and they give out free $5,000 hearing aids or $5,000 hearing aids for a $50 copay. Not bad. And it's broken down into 8 eligibility categories, depending if you're 50% or more, you're category 1. If you're into VA health care, because you signed up prior to, I think it was August 6, 2003, you'd be a category 8, okay? And you're going to get that priority of being seen for health care due to that category group. What's the eligibility? Title 10 active duty service or Title 32 502F, which is also called active guard reserve. Your character of service has to be other than dishonorable. So you have to have an honorable discharge, a general under honorable, or under honorable conditions on your discharge. If you have a dishonorable discharge, a bad conduct discharge, or an OTH discharge other than honorable, you are not entitled to VA health care. Prior to 1980, you must have completed your full period of service, and then again, this is another one after September 7th, 1980, have 24 months of active duty military service, qualifying service, or when your period when you were called to active duty has ended. They have all types of services available, periodic medical exams, chiropractic care, mental health care, and they serve over 8.3 million veterans a year. Eligibility, again, 10% or more for service-connected disability. If you have a 0% service-connected disability, you may not be in VA health care, but you will receive treatment for that condition at a VA facility. If you just returned from a combat zone within 5 years of getting back from that combat zone, you will have VA health care, but at that 5-year period, your eligibility will be redetermined at that time. If you have exposure to Agent Orange, Persian Gulf War, the new Camp Lejeune that's come out, ionizing radiation, POW, or in receipt of a Medal of Honor or Purple Heart, you are also entitled to VA health care. There's also veterans whose geographic mean threshold is below the, whose income, is below the geographic mean threshold, and they agree to pay co-payments. I believe for a married couple, it's around $52,000 in this area. And there's also CHAMP VA, which is the old military health care if you've been in the service a while ago. If you're 100% totally and permanently disabled or permanently and totally disabled, your spouse and children may be able to have what's called CHAMP VA, and that's basically like TRICARE or the active duty military health care system. Though in most cases will not be treated at the VA. Service-connected rated at 50% or more on receipt of VA pension, complete free health care, all right? The VA health care may incur co-payments, and I've already covered most of this stuff. One of the big things that's not utilized a lot out of VA health care is the implements you can get, or RX medical equipment, such as wheelchair ramps, wheelchairs, walkers, adaptive devices, such as they're great at prosthetics down there, shower seats, and all that kind of stuff is available if you're in VA healthcare. A lot of my older veterans have gotten into VA healthcare just to get some of these accoutrements to go on with their healthcare.
As alluded to earlier, there's also a nursing home care system that is with the VA, and New York State has 5 state veterans nursing homes. One's located in Long Island, one's located in Queens, and then one is located in Oxford, New York, one's located in Montrose, New York, and then the last one is located in Batavia, which is out near Buffalo. And the important thing to know about these state veterans nursing homes, it's actually a 2-part statement. Part 1 is for any veteran who is able to get into one of these nursing homes, the cost of receiving this high level of skilled nursing care is significantly less than you would pay in virtually any private nursing home in New York State. In addition to that, if you're a veteran who has a service-connected disability rating of at least 70%, you receive that skilled nursing care free of charge. The cost is reimbursed to the facility by the VA itself. No money comes out of the veteran's pocket, so it's a very important benefit for all veterans, but especially those veterans who have a 70% or higher disability rating. And the eligibility for getting into these state veterans homes is much simpler than many might think as far as qualifications on the veteran side. You have to be a New York State resident currently or have entered military service at a location in New York State. You have to have an honorable discharge, and you have to have at least one physical or mental condition that requires the attention of a skilled nursing care provider. There's no requirement about having served in combat. There's no requirement about having served for a certain period of years or anything like that. There's a lot of misconceptions on that front. The requirements as far as your basic eligibility are rather simple. On the VA pension side, there is a pension that's still available for individuals who are receiving skilled nursing care. It's reduced down to $90 for anybody who is in a nursing home other than the 5 state veterans homes that I mentioned earlier. Basically, it's a Medicaid disregard, and you can find the technical requirements if you're interested in all the specific details in Title 38 of the U.S. Code. But essentially, in case you hear about a veteran whose pension benefit is bumped down from an old amount to only $90 monthly, that's because of this Medicaid disregard. There's also community-based health care assistance that the VA offers. There's hospice provisions. There's palliative care provisions, end-of-life care provisions, community residential care. There are programs through the VA where individuals who meet certain qualifications as far as the level of their disabilities are able to receive primary care in their homes. And so when you talk about the importance of individuals aging in place, the VA is able through a lot of these programs to help make that possible.
Okay, I'll change gears and talk a little bit about mental health counseling under the healthcare system. There's a thing called vet centers that were established right after the Vietnam War because Vietnam veterans did not trust the government or trust the VA. And they provide quality readjustment counseling in a caring manner. Vet centers are designed for combat veterans and their family members, okay? So you either a combat veteran or you're in receipt of a expeditionary medal or campaign ribbon, you can go ahead and get counseling at the vet centers. One of the great things about the vet center is your records are sealed at the vet center unless you release them. So I have a lot of police officers down there, corrections officers, there's state troopers down there, there's Navy nuclear active duty people down there. It is a great system because they can go get the help they need without fear for their job or anything else. So I'm a big advocate of utilizing the vet centers. And they're excellent counselors down there. This is my #1 go-to place when I send veterans out for counseling. They kind of really specialize in the PTSD area, especially with our Vietnam vets and our recently returning veterans. They also have a large focus area on military sexual trauma, and that can be both male and female with military sexual trauma. It's not gender specific down there. And military sexual trauma is not gender specific. And they also help with some employment benefits, and they also do substance abuse assessments and referrals. And they also will go ahead and they do some of those when they do their post-deployment health risk assessments. When they go out with the units coming back from combat, they will actually go out and integrate in their reintegration programs, which is excellent, I think. The VA is probably cutting edge on digital health records. They lead the way. I am a proponent of VA healthcare. I have 3 different healthcares. I use VA healthcare. I can go into My Healthy Vet. I can order all my prescriptions. I can do secure messaging with my doctor and discuss, personal issues with him or her over secure messaging. I can push a little blue button on My Healthy Vet and download my entire medical record on a pen drive. If I go on vacation, I have my entire medical record on a pen drive should I have an emergency and have to go to a hospital. It's an excellent system, and they can continue to prove it every day. One of their biggest things they're working on now is telehealth, where they have all these community-based outreach clinics out and about, especially in the North Country. And if you need a speech pathologist, for example, they can go ahead and get a speech pathologist from Albany VA Medical Center, and they can do it all the way up to the Plattsburgh community-based outreach clinic. So excellent things they're doing there. Okay, I'm going to talk education benefits, and this is really at a glance. Like I said, I could spend 2+ hours on education benefits. A lot of information here, but the big education benefit everyone used to know about was the Montgomery GI Bill, what's really called the Montgomery GI Bill Active Duty. Basically, it's going to pay the veteran, and then the veteran is going to pay the school to go to school, or the non-degree program, or the apprenticeship program, okay? It'll pay up to $1,788, or if you're at half-time or less, it'll pay the amount of tuition and fees. But again, the veteran gets paid, the veteran then goes ahead and pays the school. One of the biggest changes and one of the best GI Bill that's pretty much ever come out is the post-9/11 GI Bill, or Chapter 33. It'll pay all in-state tuition and fees are paid, plus a living stipend, plus a book stipend of $41.67. All of these are prorated on rate of pursuit, and your eligibility tier, that could be from 40% all the way up to 100% tier if you have 36 months of active duty military or 36 months of qualifying military service. There's the Montgomery GI Bill Selective Reserve, where you signed up into the National Guard or Reserves and you said, I'm going to sign up for 6 years. They're going to go ahead and give you a notice of basic eligibility, and you can go ahead and use Chapter 1606. And then again, if you had filed a compensation claim and you were rated 100% permanently and totally disabled, there's Survivors and Dependents Education Assistance, or Chapter 35 benefits. And that one is a little different. It'll pay up to 45 months of benefits and about $1,000 a month at the full-time rate for any of the children or spouse of a veteran. There's a thing called delimiting date on these, which means you have to use the benefit within 10 years of leaving active duty military service. The caveat is the post-9/11 GI Bill is actually 15 years from your last 90 days of active duty military service. After that, the benefit is complete. Burial benefits. Burial benefits for a veteran, they provide, this is from the National Cemetery Administration. They're going to provide gravesite at any of the VA national cemeteries if space is available. They will do the opening and closing of the grave. They'll provide the grave liner, which is about that $1,500 concrete box you see there. Government headstone and marker, however you would like it done. Burial flag, a presidential memorial certificate. And the key thing is that both the veteran and the spouse are eligible to be buried in a national cemetery in either order in which they die. The one caveat is the veteran is always buried on top. So if they will resume the body if they were buried in a different order. The veteran's information will go on the front of the gravestone, and the spouse's information will go on the back of the gravestone. So you're together in life, you'll be together in the afterlife.
When it comes to eligibility for burial benefits, it's one of the simpler sets of eligibility criteria in the VA benefits realm. Most important criteria, of course, is that the individual veteran served on active duty in the military and was discharged under conditions other than dishonorable. So this is one of these benefit sets where you don't have to have exclusively an honorable discharge to be able to exercise this benefit. As far as time periods, for individuals who were enlisted after September 7th, 1980, or individuals who served as an officer after October 16th, 1981, anybody who falls into those categories, who served after those particular time periods, must have completed a minimum of 24 consecutive months of the full period of active duty in order to qualify. Active duty for training does not qualify toward those 24 consecutive months. And this is a benefit also for individuals who are in the National Guard or in the reserves, who often are not eligible for federal benefits, would be eligible for burial benefits if at the time of their death they were entitled to retired pay or would have been over the age of 60. If a National Guard member or a reservist meets those categories, then the survivors are eligible for burial benefits from the VA. What types of benefits are available in terms of expenses reimbursement? Paul mentioned the different services in terms of national cemeteries. In addition to that, if the veteran's death was service-connected, the VA will pay up to $2,000 in burial expenses reimbursement to the survivors. Now, it's important, thinking back to a topic we covered earlier, that if the death is service-connected, the survivor should also be applying for DIC, dependency and indemnity compensation, because you have a service-connected disability death. If the veteran who passed away was in receipt of a VA compensation rating or VA pension benefits, the VA will pay benefits if the individual was in a VA medical facility of any kind, including a VA nursing home, at the time of his or her death. And if the veteran is not buried in a national cemetery or a state veteran cemetery, the VA will pay a $744 burial plot allowance to help offset the expenses of the burial in a private cemetery. In addition to all of this, looking on the New York State side of the fence, the state offers a supplemental burial allowance, where the state will pay up to $6,000 to offset funeral and interment costs, so burial, cremation, or other methods. This comes into effect after the VA pays whatever they are going to pay. So the first application has to go to the federal government. The second application, if there are still unreimbursed burial or other interment expenses, would go to New York State under the Supplemental Burial Allowance Program. They say that nothing is definite except for death and taxes. We just talked about death, so now I guess we'll move on to taxes. There's a system of real property tax exemptions that New York State offers, not only to veterans but also to their families if living in the same household. These are all found under Section 458, Section 458A, and Section 458B of the New York State Real Property Tax Law. They're administered on the local level by your local tax assessors. So to make an application, the veteran or the spouse would go to the local assessor's office to file the application and provide the assessor with the proof of military service. These can get complex, but on a basic level, you're looking at a 15% basic exemption for serving in the military. then an additional 10% exemption on top of that if the veteran is a combat veteran. And you can also get an additional amount added on to your basic 15% based on your VA disability rating. The tax assessor will take half of your VA disability rating, so if it's a 100% rating, you get 50, and so on, added to your property tax exemption. There's a sliding scale in the law which determines how much money you get off for your exemption based on what your disability rating is. Earlier, Paul talked about individual unemployability, where you can have the VA recognizing you as being essentially 100% disabled, even if you don't have a specific disability rated at 100%. In that situation, if your veteran is individually unemployable in the eyes of the VA, that veteran receives the 100% disability rating in the eyes of your local tax assessor when determining what your rating should be for property tax exemption purposes. There's a separate exemption which functions in a similar but not entirely equal way for Cold War veterans. And then in addition to that, there's a school tax exemption in certain locations. It's a local option. Local school districts can vote to add in an exemption to the school tax piece of the property taxes. Right now, there's a few hundred districts throughout the state that have added those in. So if a veteran falls into one of those districts, he or she is eligible for an exemption on the school tax portion of the property tax as well.
And one caveat to this, depending on your municipality, they may require you to recertify every month. I end up writing quite a few letters for a couple of municipalities in my area. All right, we're going to touch on a couple state benefits here for education. The first one is the New York State, what's a lot of times called the Combat Veterans Tuition Award. And it's if you are a veteran of Vietnam, Persian Gulf, and Afghanistan conflicts, you're eligible to receive the New York State Tuition Award. It'll either pay 98% of tuition and fees or $6,950, whichever is less, at a New York State institution or equivalent at a private institution. You must be in receive an Armed Forces Expeditionary Medal and a New York State resident after February 28, 1961. It'll pay for 8 semesters of undergraduate, 6 semesters of graduate, or 4 semesters of vocational or part-time. And the key thing is or part-time equivalent on all of those. To apply for this, you're going to apply through the Higher Education Service Corporation, and you would go in and do the free application for federal student aid, and then you would do the Pell or the TAP grant, and it will go ahead and take you on the website right down to the New York State Veterans Tuition Award, which is a grant. One nice thing about the New York State Veterans Tuition Award, this is actually the net payer, the last payer for any benefits, so you can use it in conjunction with your post 9/11 GI Bill should you need to. We did get a waiver a few years ago to allow us to do that. New York State Regents Award is for children of deceased or disabled veterans, and it provides up to $450 a year to students whose parents served in the armed forces during specific times of national emergency, basically wartime service. You must have a 40% or more service-connected disability, be a prisoner of war, or classified missing in action. And the key thing, this benefit is it'll pay out in 2 payments, and you must apply prior to June 1st every year. New York State Military Recognition Scholarship. And the key thing here is while a New York State resident died or became severely and permanently disabled while engaged in hostilities or training for hostilities, as determined by the Higher Education Service Corporation. Notice I did not say the United States government, I did not say the military, I did not say the Department of Veterans Affairs, by the New York State Higher Education Service Corporation. It's going to pay a full ride, basically 4 years of undergraduate full-time study or 5 years in an approved 5 years bachelor degree program. So if you're doing a 5-year PT program, it'll pay that entire thing at any SUNY or CUNY institution or a private one at the highest rate of SUNY or CUNY institution.
One last program on which we'll touch today is an employment program that the state of New York offers. It's contained within Section 55C of the state civil service law, and this is often referred to as the 55C program. It looks at the creation and hiring of veterans for positions that are entry-level positions within the state government. It's aimed at wartime veterans with disabilities. Importantly, the disability does not need to be service-connected in order to qualify. The disability can be incurred from any source. And the important piece here is that it does not require a veteran who is entering one of these entry-level positions under Section 55C. The veteran can go in without taking the civil service examination for that position. So the idea is it removes one additional barrier to a veteran receiving employment when he or she comes back and separates from military service and returns to civilian life. And this continues in effect even when there is a hiring freeze in the state government. The 55C program still exists. You can still hire someone in a 55C position. Now, importantly, the veteran must meet the qualifications for the posted position. You can't have someone just going in without meeting the minimum quals. But if someone does meet those threshold standards, this provides an excellent way for that person to enter a position in the state government without having to go through the process of taking a civil service exam. And then one additional piece that I'll throw out there on the civil service exam side is if someone is serving on active duty for any purpose, including active duty for training, and that individual wants to take a civil service exam in New York State, but is unable to take the exam because of his or her obligations to military service, that individual can contact the Department of Civil Service, and they will reschedule the civil service exam for that position, for that particular individual so he or she can take it, because the reason he or she missed it was because of meeting military obligations.
And you can tell this is an excellent program because I was hired under this program during a hiring freeze.
So Paul is living proof.
I am living proof that this is a great program.
So where does this all end up? Well, we've thrown a lot of information and a lot of acronyms and a lot of most likely foreign terminology at you in the course of just a couple of hours here. As I mentioned earlier, the goal of this is not to make each of you 100% subject matter experts memorizing every single thing that's in these slides. Because frankly, Paul and I do not know every single thing in these slides from memory. Yeah. We know where the reference guides are to look it up when we need to. The important thing from this to take away is basically three things. Number one, know that we exist. And know that the reason why we exist is to provide the service of connecting veterans and their families to benefits and programs and services that they've earned as a result of their military service. Number two, takeaway is to make certain that you're asking the right questions to find out if you have someone who you might be able to refer to us. And the most important question in that group is not, are you a veteran? There are many veterans out there who do not self-identify as veterans for a whole variety of reasons. The better question to ask to get a more accurate response from somebody is, have you ever served in the military? And then, of course, we've talked a lot today about different benefits that are available for spouses of veterans. So you would also want to ask the question, did your spouse ever serve in the military? And then once you get an answer to that question, you can follow up with additional questions, such as, did you or your spouse serve during a period of war? And make certain when you ask that they understand we're not talking about serving in combat, we're talking about serving during a time when Congress said the U.S. was at war, regardless of where they were assigned to serve. You can then work with them to locate their discharge paperwork, the most common one today being the Department of Defense Form 214 or the older equivalents that Paul mentioned earlier. And if you hear certain things when they talk to you that sound like something that we might have gone over today in the course of this presentation, that can be a signal where it might be a good idea to refer that veteran to one of us for services. And we have 68 field offices right now throughout New York State, each one staffed by a Veterans Benefits Advisor who has accreditation to represent veterans in VA claims and who also is a subject matter expert in state veterans benefits as well. So you're not sending them off to Albany somewhere if the person is located out in Buffalo. We have offices that are close to wherever that person is located. and we will do whatever is necessary to work with that person and help them get the benefits that they're entitled to.
And make sure that you understand that most of the time veterans may be their biggest barrier to getting veterans benefits. A lot of them, especially Vietnam War, I served, I don't want anything to do with the government, they don't know me, I don't want to have anything to do with them. So it's really how you couch them getting, their veterans benefits and really try to link them up with the New York State Division of Veterans Affairs Advocate. Like Ben said, we have them all over the state. We are close by, and if we're not close by, we have county partners that are probably accredited with us that are close by. And the last thing I'll ask for the veterans out there in your organization, get involved with veterans issues, get involved with other veterans. We in Saratoga County have the Saratoga County Peer-to-Peer Mentoring Program, where we have over 50 mentors helping our recently returning veterans get back into society as productive members. So if you have members in your organization, I'd ask you to kind of plug in with some of those organizations out there and continue to serve our veterans out there. Last thing we'll leave you with is if you need more information about the New York State Division of Veterans Affairs or how we can help you connect to those benefits that you're entitled to and you deserve out there, or your veterans you run across are entitled to, I'll give you our website up there at www.veterans.ny.gov. And we recently launched 2 mobile apps, one that works on any iPhone product or Android product. So we have the Google Play one and the App Store out there for Apple. You can go ahead and download that app. I have it on my phone, and it can instantly connect you with whatever benefits you need. And it may spark some interest in benefits you didn't know you were entitled to.
So in closing, we thank you for the services that you provide for veterans throughout New York State and for non-veterans as well throughout New York State. And we urge you to contact us and let us know how we can assist you in helping the veterans whom you serve. Thank you very much.
Thanks for your time.
The contact information for both of our presenters and Paul Noonan is located within your presentation. They are available to you if you have any questions about referrals or if you're looking for more clarity around any of the information contained within. At this point, I would like to thank the 3 gentlemen for being here today and for sharing their knowledge, their passion, and their time with you. I would like to thank all of you for joining us today. I ask you enjoy your day, and bye now.